I'm pleased today to be joined by four partners from Morgan Lewis. Lee Harding and Polina Whitaker are in the UK and focus on cybersecurity and its intersection with employment law. Mark Krotowski is in Palo Alto. Reese Hirsch is the co-chair of Morgan Lewis's privacy and cybersecurity practice. And I'm also joined by Bobby Horn here at Alliant Insurance Services, and he is one of our senior advisors on cyber liability. Those of you that heard me before, apologize for some repetition, but quickly as we want to make up for some lost time, it's often said there are three types of companies: those that have been hacked, those that have been hacked and don't know it, and those that haven't been hacked yet. According to Ponemon's 2018 survey, the cost of a data breach was almost $4 million on a global basis and nearly twice that in the U.S. Of breaches tracked, an overwhelming majority of those companies would qualify as a middle market sized company. Okay, so we're going to have to walk through this just quickly. We seem to be having some technical difficulty with Reese with Lee and Polina in the UK, and I apologize for that. We had them for a brief moment, but it seems to have failed us again. So quickly, I think it's important to note here that it's mission critical as corporations to ensure that you have a qualified incident response plan in place, similar to responsible corporations that have necessary plans in effect to respond to large property losses. Similar, said basically, we have a break glass in case of emergency type protocols. No, it should be no different, even though this amount of property, when we talk about data, property is an intangible asset. We look to have incident response plans in effect to ensure that we take a measured approach to respond to circumstances when data may be lost or is in fact lost or stolen. It's important that everyone that's a part of an incident response plan team know their role and responsibility, and that the key areas of the organization understand what part they play during the crisis time of a breach. For many companies, it has to start at the C-suite. You have audit level responsibilities, audit committee responsibilities, interacting with legal, there's compliance, obviously IT and security. Human resources plays a large role, especially if employee personnel data is impacted. And potentially, if you interface with customers on a business to consumer basis, we come into circumstances where there's a large public relations effort, not only on behalf of the company's reputation, but also to ensure that customers are taken care of from a monitoring standpoint to make sure that their credit is not adversely impacted, and to ensure that they have available and necessary hotlines to dial and ensure that they are not being adversely affected. Obviously, as well, there could be vendors that might be impacted in a business-to-business breach, and those need to be notified on occasion as well. It's critically important that you engage competent and qualified legal counsel to help you navigate this process. In the insurance world, we often call these folks breach coaches, and those lawyers are approved by insurance companies to work with you through the time of crisis. So with every plan, it's important to practice that plan, much like children go through fire drills at school to make sure they follow an orderly and seamless exit from the building if there ever was an unfortunate incident where there might be a fire. This, too, is important to practice. You need to meet and, like I said, understand their roles and responsibilities so that the people involved do not act in a panic mode if and when there is a breach. It's often said by first responders that one of the hardest things to do in a crisis is to actually dial 911, and so they encourage people to practice that. This is something that, although maybe less serious on a personal level than dialing 911, really is no different in that it is important and imperative to practice your roles and responsibilities. Run scenarios in advance. Run different tabletop exercises to ensure that what you're doing is measured and understood and that everybody knows who to talk to next and who to hand the baton to if and when the time is appropriate. They said that boils down to conducting regular training. Training can be done both in person as well as through software-based exercises. Hiring outside vendors can help you to put you through the paces on certain more real-time and prominent types of breaches. One thing to note here is that we use acronyms a lot. This is often called an IRP. A part of an incident response plan or IRP is something called a WISP. A WISP is different from an IRP. It makes up a portion of an IRP, and a WISP is a written information security protocol. That is a mere one leg of the stool and also is something that should be practiced. Employees and executives should be put through regular training on a written information security protocol to make sure that people that come in contact with certain segments of data are, in fact, handling it appropriately, dealing with it in a proper and secure way, and ensuring that it does not fall into bad actors' hands or is exposed to a circumstance that might result in an unwanted party accessing data. So as we talked about, there are a lot of different stakeholders in the process, and to help you through these processes, it's imperative that you have qualified external resources in place during a time of crisis. This is part of an incident response plan so that you know who to call, when to call them, and what role they play. In addition to those people internally, you have resources lined up externally. If there is a suspected breach or an actual breach, you have to engage first with counsel, then with a computer forensics firm to identify the source of the breach, remediate the breach, and stop it from reoccurring. And then you're going to have to engage in the other areas that include public relations, as well as dealing with various regulatory bodies. It's important to work together as a team, that you engage with counsel early so that you can invoke privilege with counsel so that the actions that you take are protected to the extent they can be protected by privilege, and that you take the steps to have a measured and proper response. Bobby, can you spend a minute and talk about how the insurance policy can interplay with the lining up of external resources?
Certainly, yeah. Thanks, Brian. Yeah, so we'll get into this a little bit later, but just to kind of give a brief overview, that if you do partner with an insurance company and you buy a cyber liability policy, as part of being a policyholder of that carrier, they do partner up with various vendors, if you will, whether it's legal counsel, computer forensics experts, PR, crisis management. You have access to a list of vendors that you can utilize in the event of a data breach. So rather than having to pull these things all together on your own, if you partner with an insurance company, you have access to these specific vendors.
Yeah, insurance carriers have taken great measures to work with the appropriate outside vendors to make sure they have the right vendors in place, in line for certain types of breaches, right down to the industry sector to make sure that if there is a data forensics firm that is more appropriately deployed in a breach responding for a financial services company, that they respond, that they don't engage that firm if there is a breach at a university or a healthcare organization. So what we have here now is we were hoping to have Lee help us.
Can you hear me, Brian?
Oh, there. How about that?
Here I am.
We're back. The gang is all together. Okay. Here we go. Okay, Lee.
Good.
So we're all set up now. Fantastic. So Lee, thank you for jumping on here. You put together a case study for the audience that provides a hypothetical data security scenario that would involve a truly global response. Can you take a few minutes and walk us through it?
Absolutely. Very happy to do so. So we have a hypothetical airline here, ABC Airline. They operate in a number of different countries around the globe. The board of the airline is concerned, rightly so. A number of high-profile media stories criticising companies in relation to their cybersecurity protocols and their sort of readiness to respond to particular breaches. And you've already heard a bit about that. The board appoints an employee, Jim Warren, who's head of compliance, to review the airline's processes and to make certain recommendations. And so Jim, he wants to manage the board's expectations when he's asked to make a presentation at a board meeting. And what he wants to know in the first instance is, what does the board need to know? And we've already sort of heard a bit about that already. So the key points that you've heard previously is that to some extent data breaches are inevitable. No firm's policies and processes are perfect. So that's not to say that you shouldn't have the right processes in place, whether that be through the right encryption or the right software processes, such as around patch management, firewalls, malware protection, or sort of just more mundane things such as passwords and making sure employees are properly trained. So you definitely ought to be doing all those things. But you also need to be ready to respond as a team, to mobilise quickly as and when these issues arise. So the key really is prepare. And so Jim has reviewed ABC Airlines processes and policies. He's happy with those, and he wants to know what does he need to do next. And the key thing is to make sure that it's not just a paper exercise, that this actually works in practice. 18 months goes by, nothing happens, and then suddenly there's a massive data breach. And so we need to respond. So Jim reassures the board, happens late on a Saturday night, as these things always do. He tells the board the incident response team is assembled, they've implemented the plan, and local counsel is engaged and is advising on data breach management. So what are sort of the legal challenges? So in terms of this breach as well, just to say, it's three different areas. It's the EU, it's also China and Russia. So just looking at it from a UK perspective in terms of data breach management, there is now an obligation for organisations to notify breaches to the regulator, generally where there is some risk that could be sort of imposed on particular individuals. And there could also be an obligation to notify data subjects if there's a high risk that would affect their privacy rights. We set out on this slide, when do you need to notify? Really, you need to do so as soon as possible, and there's a long stop of 72 hours. Obviously, it's very difficult to notify quickly when it's a sort of fast-moving situation. You don't necessarily know what is happening, and so sort of as a matter of sort of normal practice, it's fine to notify information in phases. So you might have quite high-level information at the outset, and as Brian's already mentioned, it's also important to conduct the investigation under privilege, because during those early stages you might not necessarily have a very clear picture of what's actually happening. So that's sort of a key point to be aware of there. What should be notified? Number of different matters, the nature of the breach, how many people were affected, what's been affected, contact details, what the likely consequences are. There will be there's a standard form that's provided in the UK. There will be reputational issues to consider as well here. So these are just the legal steps, but obviously you need to consider how you manage this internally and externally. Make sure your messages are consistent, and you may want to sort of get ahead of these issues early. So a number of companies, for example, will approach customers and may provide them information which will allow those individuals to take steps to protect their personal data and remediate any risk to them, but also just as a general sort of good housekeeping point, and maybe sort of offer compensation as well, just to sort of just to protect the brand of the company. In terms of Russia, there's no strictly speaking, sort of black letter requirement to make a notification to the regulator or to individuals, but as a matter of best practice, it's always recommended that employers should voluntarily do so. And then in China, there's quite a recent development there. So we have the PRC cybersecurity law. This does introduce a general requirement for the reporting and notification of actual or suspected data breaches. And just a general point on this, I'm sure this has already been covered by Brian. It can be quite unclear early on, has a breach actually taken place, and there might need to be some investigation to determine that as well at an early stage. But in terms of China, there's no strict time frame as to when breaches should be made, but there is a draft as to when notification should be made. But there is a draft regulation at the moment which suggests that the notifications ought to be made to both the regulator and often there'll be local regulators as well, and the individuals within 24 hours.
Thank you very much. Appreciate that insight. And so now we're gonna pivot and speak specifically to the GDPR and its broad reach. Polina, are you with us? And would you care to kick it off?
I am, certainly. Yes. Hope you can hear me. So as we know, the GDPR has now come into force. We've had it in place for coming up to 9 months. It's replaced the European Data Protection Directive, and it's important just to be aware that we don't just have the GDPR, we've also got 28 other European local laws that supplement the GDPR. As we all know, anyone who's worked in this field, it's really expanded the concept of European data privacy obligations, and it applies extraterritorially, so it applies to controllers and processors that not only are based in Europe but also that are based outside of Europe, but that offer their goods and services into the European market, or who conduct monitoring of individuals whilst they're in Europe. Concepts of personal data is pretty much the same. It's pretty much any data that can identify an individual, even if other data from another source is needed to do that. Turning to the next slide. The requirements for personal data to be processed lawfully and fairly are still applicable here. In general terms, consent has to be explicit, freely given, and fully informed. Certainly very important for the higher bar of consent to make sure that it's absolutely clearly documented and people have the right to withdraw consent as well. Privacy notices, turning to the next slide, are an absolutely crucial document. I'm going to come on to some of the detail in just a moment. Some of the rights to control data under the GDPR have been strengthened. We've always had the right to be forgotten and the right to have data corrected or deleted, but they've really been strengthened. And now there's no fee that the individual has to pay. So, we've certainly found that a lot of organisations are being very much burdened by these requests coming in because they're pretty extensive. The consequences of not dealing with them comprehensively are great, and we found that the supervisory authorities in Europe have been really, very sort of focused on complaints made by individuals that their rights haven't been respected. There are some additional rights, including the rights of privacy by default and privacy by design. So certainly from a technological application process, from a sort of a WYSI app-based collection of data and other examples, you've got to build in from the design perspective privacy enhancing measures. And then, as we've heard about from Lee's session, there's a requirement to notify the supervisory authority without undue delay and within 72 hours unless there's unlikely to be a risk to the rights of individuals, their privacy rights. And if there is likely to be a high risk to individuals, then there's an obligation to notify the individuals themselves, but certainly the authorities want to know first of all, and even if there isn't a statutory obligation to notify the individuals, they might well say to the organisation that they've got to notify the affected customers or other individuals whose data has been compromised. So the penalties are very steep. They are up to the higher of 4% of global annual turnover, or 20 million euros, and both controllers and processors are directly liable under the GDPR. As I've mentioned, there are local laws in each European country. Germany was first past the post and is looking at revamping its local data protection laws. There's nothing to stop a European country from gold plating and enhancing the obligations under the GDPR. Just turning to privacy notices, thank you. The detail is all set out in the slide. I won't go into it in detail. It's very much for your takeaway, but it's a pretty prescribed document, and it's really to deal with the right of transparency under the GDPR. That's a very it's been very well publicised. It's a little bit more difficult to do in practice than might appear, but certainly the basic key point is that it's important to tell individuals how you are using their data, even if you don't get it directly from them. So these privacy notices ought to be on websites. They ought to be in documentation and terms and conditions. Pretty much as you can do to promote them, they ought to be included in all of the sort of materials that deal with legal terms or policies. Going on to some case studies, just turning to the next slide. Sorry, Brian.
No, I was just saying. I was just going to say you have some case studies for us that I think would be informative for the audience.
Yeah, absolutely. Just to give a bit of colour to how some of the GDPR principles work in practice. So we've got a Spanish retailer that wants to engage a Malaysian vendor to process customer orders online. So the first question is, what agreements must it have in place? So we've got a European entity that is a controller. It's the one that's selling directly to individual customers. And it wants to engage a Malaysian entity to be its processor. So there's two agreements that are really key here. One is a data processing agreement, and that has to meet the GDPR requirements that, again, are quite prescriptive. And then secondly, because it's transferring customer data outside of Malaysia, it will need to have in place a data transfer agreement or a standard contractual clauses agreement, unless there's any other safeguard in place. So the standard contractual clauses are all European Commission approved. They're in a template form. The old agreements are still valid under the GDPR. The European Commission is likely to be revising the agreements, but at the moment the old versions are still fine. And then in terms of liability, theoretically processors and controllers are both directly and separately liable under the GDPR, but certainly from an enforcement perspective, it's very likely that the Spanish retailer is likely to be the first in line, as it were, because it's obviously within the European jurisdiction. It is quite difficult to be internationally enforcing a GDPR penalty, even if it's the Malaysian vendor that's actually liable for any kind of data compromise or data breach. So certainly the Spanish retailer is going to need to make sure it's got the right liability provisions or insurance provisions, frankly, in place so that it's protected adequately. In terms of appointments, the Malaysian vendor, because it's going to be using and providing a service to European organisations, it's going to need to register itself as a European representative. If its main customers in Spain, it definitely needs to register with the Spanish authority. And that can be generally done online, and there are also sort of third parties that are available for these sorts of services. And it's unlikely that either party needs to appoint a data protection officer in this scenario. The GDPR requires it for certain high-risk processing like healthcare data or biometric data, but it's unlikely to be applicable here, even though there might be card payment data. That's not one of the sort of highly protected categories of data in the GDPR. Coming on to the next one, we've got a US IT company that wants to sell services to European businesses. The first question is whether the US company is subject to the GDPR, and the answer to that is yes, because it's selling its products and services into the European market, so it will be in the course of providing those services, even if they're B2B, collecting European personal data, even if it's just individual staff at the business customers. And so the IT company is going to be subject to the GDPR. How can it comply? Well, certainly one of the things it'll need to do is make available a privacy notice to its customers, and it doesn't need to send it directly to the individuals at the customers, but certainly should make it available, even if it's just on the website. I'd certainly recommend appending it to terms and conditions. It'll also need to have in place probably a standard contractual clause agreement. This is now an obligation on both sides of the data transfer arrangement, whereas it used to be always on the European exporter. I'd certainly always recommend doing some sort of audit or some sort of assessment of what the GDPR risks are, what the requirements are for those risks, and then manage them accordingly. It will need to make a representative appointment as well in Europe, and if it's a pan-European business, it should probably just pick one organisation in one country where it does its main sort of source of business. And then the final question on transfers: it can lawfully receive sales data in the US if it's got some sort of either model clause agreement, and then the other alternative is, of course, if it registered with the Privacy Shield arrangement, then it can also just receive data through the Privacy Shield mechanism as opposed to having individual agreements in place. So turning to the sorry, Brian, go ahead.
No, Paulina, I was just going to say it's next to impossible to talk about Europe these days without talking about Brexit, and whether it is going to happen or not is still pending, or the degree to which it's going to happen. And so if you wouldn't spend a little time for us, please, talking about the potential impact of that and what companies and our audience should be aware of.
Yeah, sure. Well, as of today, it's still unresolved, unfortunately. It looks like we're not now going to get a vote today. So by default, we're looking at leaving the EU in 10 days' time, unless there's an extension or some sort of deal is done in the next 10 days. So assuming that no deal is done and there's no extension, and the UK leaves the EU without a deal, then we won't have an adequacy determination from the European Commission. We don't get it by default. Even though in the UK we've got the Data Protection Act, which pretty much replicates the GDPR, we would still need an actual determination from the European Commission, which is definitely not forthcoming until some sort of agreement is done on the exit process. And so because of that, theoretically a transfer from mainland Europe to the UK would be restricted because we wouldn't have the adequacy determination. So we're a third country, a bit like the US or Russia or China. And so because transfers to the UK from Europe are restricted, model clauses will need to be put in place from a European entity to the UK, where there is an entity-to-entity transfer of data. Also, privacy notices ought to be updated just to make clear that transfers of data do happen to the UK as much as other third countries. Interestingly, the transfer of data from the UK to the rest of the EU will not be restricted because we very much in the UK view the rest of Europe as being adequate. We all have the same law. And so, although there's no restriction from the UK to the EU, and there is one from the EU to the UK, we have said, the ICO in the UK has said that the model clauses approved by the European Commission will be valid. So anyway, if we're transferring data from the UK to a third country, like the US. So just giving a bit of colour to that, if we've got a French-based insurance company wanting to engage a UK vendor to provide certain services, including HR and payroll services, post-Brexit, we'll definitely need a data processing agreement in place. We always have done and always would do. And then for Brexit purposes, we would also need a data transfer agreement as well as we would need to, as the UK vendor, would need to register as a European representative because it's providing services to a French-based organisation. And then if a US retailer wants to market its products to UK customers, that would still be restricted under the UK Data Protection Act. And so all the requirements will continue to apply for the UK as much as the rest of Europe. If the US retailer is Privacy Shield certified, all it needs to do is just note in its certification that it also receives data from the UK as well as the rest of Europe. And our UK regulator has said that we would recognise post-Brexit their Privacy Shield arrangement, even though it's a European-approved arrangement. And if you had a UK company that wanted to share customer data with its US parent company, that would be restricted under data privacy laws because we would still have a regime that restricted transfers to third countries. But the model clauses would be valid and viable for this. So this is how the transfer of that data would be lawful.
Well, that's great, Paulina. Thank you very much for your insight. Now we're going to come back across the pond and talk about the veritable incomplete jigsaw puzzle that is the domestic regulatory landscape. Mark, there are countless agencies at both the federal and state levels that impose various post-breach requirements on companies depending upon the different circumstances they may face. Can you talk to us for a little bit about some of the critical regulatory bodies at the federal level that we need to know about and what they might impose?
Yes, Brian. As you pointed out, there are a number of different agencies. They're both at the federal and state level, and you can see some are listed on this slide, including the Securities and Exchange Commission, the Federal Trade Commission, as well as state attorney generals. There's also a very active enforcer in this area is the New York Department of Financial Services. There are also private industry standards that may apply, and you see here the payment card industry and information standards that apply to credit cards. If you look at the next slide, you can see that a company in the United States, doing business in the United States, may be subject to a variety of regulators. Just last year, the final two states, Alabama and South Dakota, joined all remaining states with their own separate data breach notification standards. What that means is if there is a consumer who resides for that company in any of those jurisdictions, then you must comply, if there is a data breach, with the notification standards for those different states. This becomes very cumbersome because the standards, while there are some similarities, often do have a number of key differences as well, and that's something that we often help companies with when there is a data breach. You also see on this slide the California Consumer Privacy Act of 2018, and our partner, Reese Hirsch, is going to talk about the requirements under this new statute that takes effect in January 2020. If you turn to the next slide, you can see that some of the enforcers are coming out with specific guidance on cybersecurity standards. And last year, the SEC did that in providing specific guidance as to what they expect out of regulated and public companies with regard to disclosures about data breaches. And what they said in that guidance is that they expect that many of the existing disclosure requirements may trigger a notification obligation for companies, such as there's risk factors that investors would need to know about. Obviously, if the information is material, those standards would need to be addressed as well. One of the points that they emphasize is the timing of the disclosures. And while they did not come up with a hard and fast time frame, they did say that that is an area that they will look at, is whether or not the timing was sufficient. And we see that with many regulators. The SEC often emphasizes the board role in managing cyber risk, and they did so again last year. They also noted the importance of the policies and procedures governing cybersecurity matters, and that's an area that regulators will look at. And then they also mentioned that given that a data breach may have insider trading consequences, they expect regulated companies to have a sufficient program to address those types of issues. If you look at the next slide, this is an important area that we see emerging across the country, and that is many states, including California, are imposing what is known as a reasonable cybersecurity protection standard. And the failure to have a standard in place may result in a claim and liability. And so this is an emerging area that we are seeing among many different jurisdictions. On the next slide, we turn to the issue of notification. And both Lee and Paulina talked about notification in Russia, China, the UK, and the GDPR. And this is something that is also very important whenever we assist in the United States, given federal and state regulators. As you can see on this slide, there's many different issues that arise whenever there's notification, and it has become an area that regulators are looking at very aggressively. As you can see on the next slide, there are notification is important because there are now 54 U.S. jurisdictions that have different standards, as we mentioned. That's all 50 states, the District of Columbia, Puerto Rico, Guam, and the Virgin Islands. The first notification standard was in 2002 in California, but now we have to navigate and understand and manage all these different notification requirements. When you talk about notification, as you can see on the next slide, there's two components. One is whether there is a public agency notification requirement. I'm sorry, Brian.
No, go ahead, please.
Oh, okay. Sorry about that. So there's a public agency notification requirement and then also a consumer or individual requirement. And what we see is that many states, as well as the SEC, the FTC, and others, do require, in some instances, notification either publicly or to the regulatory entity. And you see a summary here of many of the different state enforcers. A number of states require public agency notification, like California, if there are more than 500 California residents that were affected by the data breach. Some states, like Oregon, have a lower threshold, and some states want to be notified regardless of the number of individuals. But that is something always to take into account. Many of these public agencies actually have a website that publicly lists the notifications that they receive. In looking at the next slide, we can see for individuals that there are differences in terms of when to notify. Some states, like California, and we'll look at that language in a minute, require notification in the most expedient time possible, but without unreasonable delay. That is measured under fact-specific circumstances, and many regulators that have that type of language will open up an investigation regardless and then make an assessment whether the notification was reasonable. However, you see a trend where many states are imposing time-certain requirements. Polina was talking about the GDPR 72-hour notification requirement, and I can say, and all of us can say on this phone call, that 72 hours is very difficult to know the scope and the extent of the breach in terms of what you're notifying the regulator about. But New York has a 72-hour requirement, and then a number of other states are saying not later than a time certain they do expect notification. So when there is a breach and there is a cyber investigation as to what happened, managing these deadlines becomes very important. Turning to the next slide, you can see some states still have that more flexible language. And again, California and Texas, as examples, allow time to determine the scope of the breach. And all of us on this call can say that is really the one issue that drives determining what you're going to notify about is what was this breach about? Is it ransomware? Is it some other scenario? Is it someone clicked on a link and now there's a worm that's permeating the system? And each one of these takes time to determine. And so the flexibility often is important, but as we see, we don't often have that luxury. Turning to the next slide, the New York Department of Financial Service, we just wanted to mention, has become a very active enforcer in this area and has many specific requirements. One in particular is every February 15th for covered entities, which includes financial institutions, financial services companies, and insurance companies, must file a certification of compliance with a long host of various standards, including whether there's a cybersecurity policies, as risk assessments, and a number of other requirements. And so this is something that we wanted to highlight as part of this presentation. And then finally, turning to notification again, the SEC last April came out with a regulatory enforcement action in the Yahoo data breach. They imposed a fine on the company of $35 million and part of the enforcement action was based on the untimely disclosure in that matter, and that investigation actually is ongoing as well. So thank you for the chance to turn to some of the regulatory issues in the United States.
Mark, thank you very much. I really appreciate that. And as we approach the quarter poll here with 15 minutes to go, Reese, really appreciate you taking the time to talk with all of us today. Can you give us some of the highlights and key takeaways from the bill as they prepare to get compliant?
Sure, Brian. Just as GDPR changed the privacy regulatory landscape in the EU, as Paulina and Lee have touched upon, the California Consumer Privacy Act is going to change the landscape in the U.S. It was passed on June 28, 2018, and it's a unique and comprehensive consumer privacy law. It's unlike any other privacy law that's on the books in the U.S. It includes GDPR-like consumer privacy rights, and significantly, also a new private right of action for security breaches, along with potential statutory damages. And that's particularly significant because demonstrating actual damages has been a difficult hurdle for plaintiffs' attorneys bringing security breach class action lawsuits. But the future availability of statutory damages could lead, or is likely to lead, to a spike in security breach-related litigation in California commencing in 2020. And the effective date of the law is January 1, 2020, but the enforcement date is going to be 6 months after the Attorney General's office issues regulations, but no later than July 1, 2020. So most likely the Attorney General will take its maximum time frame there, and it's likely that compliance will be necessary around July 1, 2020. It's a very far-reaching law, and the International Association of Privacy Professionals estimates that it's going to affect more than 500,000 U.S. companies doing business in California, including many small and mid-sized businesses. There's been one round of amendments to the law. On September 23rd, Governor Brown signed SB 1121, which includes a number of significant tweaks to the CCPA. But additional amendments are going to be necessary because there are important issues that still need to be clarified, such as whether the CCPA's broad definition of consumer applies to employees. I think there's a strong case that these new consumer privacy rights under the CCPA don't make a great deal of sense when they're applied to employees, but as currently written, the law could be interpreted that way. The Department of Justice is still seeking input. They conducted public forums around the state to hear feedback on the law and the changes that are necessary. So businesses subject to the CCPA must be for-profit organizations or a legal entity that does business in California, collects consumers' personal information either directly or through a third party on its behalf, and the term collects is very broadly defined, and also a legal entity that either alone or jointly with others determines the purposes and means of processing of consumers' personal information. And that's similar to GDPR's data controller concept. So the CCPA creates a host of new consumer privacy rights that didn't exist before. We could talk at length about each one of them and its nuances and ambiguities, but we're just going to touch on the high points here. So the new rights are the right to know the categories of information that a business collects and uses, and that's in a much more detailed way than current law requires. A right of access to the data that a business holds, and data portability, the right to get an electronic copy of your data so that you can take it to another business if necessary. There's a right to be forgotten or a right to have your data deleted, a right to opt out of the sale of personal information to third parties, and a right to equal service and price. So a company can't discriminate against consumers based upon their exercise of these new privacy rights. So there are a number of initial questions that companies are grappling with as they prepare for 2020 and CCPA compliance. The first important one is, does the CCPA apply to your business, or do you fit into an exception? Beyond the general definition of business that we just talked about, there are some important exceptions for healthcare companies that are regulated under HIPAA, and also for financial services organizations that are regulated under the Gramm-Leach-Bliley Act or the California Consumer Privacy Act. So also, companies have to think about how many of the data elements included in the CCPA's broad definition of personal information does your business collect. It's a very, very broad definition of personal information that picks up all kinds of behavioral and consumer tracking data that current laws don't really address in their definition of PII. And companies may need to implement new data tracking mechanisms to respond to those new transparency requirements. Also, you need to think about how your business would go about organizing consumer personal information to provide the new CCPA privacy notices, which can be built off of or overlaid over existing privacy notices that may be developed for compliance with CalOPA, the California Online Privacy Protection Act, and other laws like FTC standards. Also, companies need to think about how they would implement this new right to be forgotten, which can create all kinds of difficult operational challenges. And in some cases, it may be problematic to delete data that needs to be maintained for risk management and litigation hold purposes. And also, as I touched on earlier, there's a new private right of action for security breaches under the CCPA. And plaintiffs may bring an action under that new cause of action if there's non-encrypted or non-redacted personal information that is subject to an unauthorized access and exfiltration, theft, or disclosure, and as a result of the business's violation of the duty to implement reasonable security procedures and practices appropriate to the nature of the information. And that last bullet is based off of the requirement of reasonable security in California under Civil Code Section 1798.15, which Mark referenced a little bit earlier. And as we noted, statutory damages are available, which is likely to lead to greater success and a spike in security breach litigation. More questions that your company needs to answer are, how you would go about organizing consumer personal information to provide that data upon request in a, quote, readily usable format to the consumer, something that most businesses don't necessarily do today, and ensure that agreements with service providers are CCPA compliant. And then finally, personnel have to be trained so that when requests are received for these new privacy rights, everyone understands what's necessary to grant those rights. Finally, this is also a good time to fine-tune your business's incident response plan to prepare for this likely boom in security breach litigation. And sometimes having a determination that you have reasonable security under the California law can be a useful exercise. So many details about CCPA remain unresolved. It's still a work in progress, but as you prepare for 2020, the basic framework is in place. It's unlikely that any of these consumer privacy rights are going to be struck down, but they may be adjusted or tweaked a little bit. businesses should use their time now to begin thinking about how they would comply with the CCPA, as it's currently drafted. And for a sweeping, comprehensive law like this, a year and a half prep time is really not that long, as we learned with GDPR compliance efforts. Those companies that have been through a GDPR compliance process will have some benefits of a head start, like the data mapping and privacy assessment exercises that are part of GDPR compliance are useful, but it's important to remember that CCPA is something entirely different, and GDPR compliance doesn't match up completely with CCPA compliance. It's a different exercise. And now with that, I'm going to turn it back over to Brian to talk about the cyber liability insurance risk market.
Reese, thanks very much. Appreciate it. And now we're going to bring in Bobby Horn, and we're going to go rather quickly through this exercise as we're coming up on the gun. So, Bobby, let's just talk for a few minutes about the insurance market and how it responds to data breaches and what's available out there for the buyer.
Yeah, thanks, Brian. So, real quickly, first, just want to take a quick look at these the data breaches that we've had over the last year and a half. You'll see the fines can get pretty big, and they really span all industries, really: technology, healthcare, finance, higher education, and professional services. And really, the fines are going to depend. The severity of the fine is going to depend on how egregious was the entity in failing to notify the proper authorities, as the folks from Morgan Lewis just went over so thoroughly. That's going to drive how big the fine is. And those fines are coming from the SEC, Department of Health and Human Services, the Office of Civil Rights, and the various state attorney generals.
And the good news, though, is that a portion of those fines at least can be transferred to an insurance company and off balance sheet, which is atypical from customary insurance policies, correct?
That's correct, yeah. And a lot of it's going to depend on if it was a criminal act, no, that's not going to be covered, obviously. But in the event that it is just, it's not criminal, you look to the insurance contract to see, where it's covered. And most cyber liability markets, carriers will provide some basic fines and penalties coverage, and that includes, state, local, foreign statutes. We have seen carriers, and we've negotiated, specific endorsements to include GDPR language into the form. Whether or not those GDPR fines are going to be covered or not is still kind of on the table. There hasn't been any case law yet to determine if they are insurable, but I think in speaking with a lot of the insiders, they do think that will be something that will be covered by these policies.
Let's just talk quickly about the various components of the insurance policy and how it works sort of on a continuum basis, from responding to the breach at first, notifying, working with the proper authorities, and then how to respond to potential litigation.
Yeah, so the fines and penalties piece, while obviously covered, is just a small piece of the overall pie. So as Brian said, when you have a data breach, there's certain things you need to do to respond. All those first-party costs, things like hiring legal counsel, bringing in a computer forensics firm, doing an assessment of the actual breach, those are all going to be things that are covered under the first-party portion of the policy. If there's any litigation down the road, obviously, class action lawsuits, then the policy will respond with defense and indemnity coverage.
One of the things we talked about before, too, is how an insurance company can help line up loss mitigation services to help you, the buyer, and your company present as a better risk to the insurance market. And that's just an indication of how broad and frankly, buyer-friendly or soft the insurance market is. Bobby, talk for a minute, if you don't mind, as we wrap up here, what the market is like out there now.
Yeah, I mean, there are a lot of markets now. I think there's something like 70 standalone underwriting facilities that are writing this coverage. Obviously, not all are equal, but it is a extremely competitive marketplace. Premiums are relatively flat. We're seeing slight increases of 5, maybe 10%, but it's really based on revenue size, not necessarily overall market trends with respect to data breaches. The coverages are constantly being expanded. I mean, obviously, this is a very fluid coverage. To keep up with the criminals, the insurance markets have done a pretty good job of amending their terms and conditions to react to those as well. So things like system failure coverage, which is an extension of your business interruption, betterment coverage or bricking coverage. So in the event you have a data breach that renders your computer hardware useless, the policies will give things like hardware replacement coverage to the firm. Things like cyber crime, typically covered under a standalone fidelity policy.
Well, let's talk for a minute about that, because that's an important distinction. When we talk about cyber crime, it's something that is called many things by many different people in many different walks of life. It's most commonly, though, falling under the headline of spear phishing or unsolicited emails or fake emails that are social engineering, trying to induce an otherwise innocent party to siphon funds or to wire money to what may appear to be an actual legitimate account, but is in fact a black hat, if you will, a perpetrator of bad acts. So that's something, as Bobby said, that falls, unless it's endorsed to a cyber liability policy, would fall outside of that. So what are some of the things, because a cyber liability policy isn't the bomb that soothes all, what are some of the things that people need to be mindful of in the market as they think about what they're buying?
Right. So if you're a professional services firm, you want to make sure that you have errors and omissions, because the cyber policy is not going to cover things, it's not going to cover the service you provide to others for a fee. So whether it's technology or other professional services, you want to look to make sure that you have the proper coverage under an E&O form. As Brian said, the crime piece. Traditionally, the cyber crime was covered under your fidelity policy, but there is some gray area there. So now we are seeing the cyber markets provide some kind of supplement what you have through the fidelity policy. But yeah, as Brian said, the cyber policy, while providing lots of coverage, is not the be-all, end-all. And as we can tell you from the broker side, not all policies are created equal. So it is important to make sure you go through the terms and conditions to make sure that what you're paying for is what you get.
And I think just to recap, the value, one of the big drivers of value in purchasing the insurance product is the coordination that the policy and the insurance company will provide for an actual response for a data security or data breach incident. Can you talk about that again just for a minute to make sure that the point is clear?
Right. So, typically most of the clients we work with don't necessarily have the resources to go out and hire a legal counsel, computer forensics firm. So when you partner with an insurance carrier, they have, like I said earlier, they have all those vendors lined up. So they act as whether they call it the breach coach or your breach counsel. They will quarterback the entire situation. The metaphor we use a lot is of a general contractor. You wouldn't, if you're building a house, you're not going to hire the carpenter. You're not going to hire the plumber, the electrician, HVAC guy all on your own. You're going to hire a general contractor to take care of all that for you. In similar way, the insurance company will act as your general contractor and quarterback the entire process. They'll bring in the proper legal counsel, the computer forensics firm, public relations, all the credit monitoring services you need to do in the event of a data breach and you have to notify. They really take that burden off of the policyholder, off of the client, and make it a lot easier for them to manage and mitigate any potential loss.
In sort of the opposite of that, though, if you have lined up vendors or you have trusted counsel, a firm like a Morgan Lewis, for example, you certainly want to work with your insurance carrier to make sure that they are recognized and approved for the work that needs to be done. The example we often use is you may have a dear friend that you've known for 30 years and he's a great real estate attorney, but he may not at all understand any of the notification requirements and legal obligations imposed upon you as a company by the 54 jurisdictions in the U.S., let alone what's existing overseas. So it's important that you look through this with clear eyes and understand the value of having the right people engaged and ensuring that the insurance company with whom you choose to partner recognizes and accepts the vendors that you may have lined up in advance, i.e. counsel, outside counsel, because at the time of a breach, getting that agreement can be incredibly difficult and burdensome.
Right, and as Lee mentioned earlier in the presentation, prepare. You don't want to have those calls, after the breach. You want to have those calls, those conversations up front when you're binding a policy or immediately after. It's, again, depending on the carrier, some are more flexible, but for the most part, they are willing to work with their clients, their policyholders, in getting the proper vendors added to the policy.
So that wraps up the presentation today. I want to thank everybody for their time, especially my fellow panelists from Morgan Lewis and here at Alliant. I want to also take the chance to apologize again for the initial glitch we had with the software, but appreciate everyone sticking with us. I hope you found this to be informative. There will be an opportunity to email questions in, and we will get those disseminated to the right people so that you do get an answer if you do have a question. Once again, thank you all very much.